Bouquet, channel 628. Hashtag on the move and connect with us.
Well, we certainly are speaking about this very important talking point for today, speaking about the conflicts that are taking place in Cameroon. 6 years on, the crisis in the Anglophone regions of Cameroon, they still continue today, with recent reports indicating that there's still people being killed, over 6,000, and further people being displaced and others becoming refugees in neighboring countries such as Nigeria. Now, the origins of these particular conflicts lie partly in the fact that Cameroon applies two different systems of law. The Anglophone lawyers say that the systems marginalizes the common law. So we'll be speaking to two common law lawyers today who have been directly involved in the Anglophone crisis of Cameroon. We'll be speaking to Barrister Richard Tambu. He's based in Bamenda, that's the northwest province of Cameroon, and has been part of these particular proceedings from the beginning of the crisis. We also have a Barrister Amungwa. He's the spokesperson for the team of lawyers defending 10 Anglophone leaders who were kidnapped 5 years ago and sent back to Cameroon from Nigeria. This was in violation of international law, and this is an ongoing case that's still taking place. Don't forget to head on over to our On The Move poll. We'd certainly love you to participate in this conversation by doing so on the poll at Channel Africa 1. That is our Twitter handle, and of course we want you to be a part of this conversation. Well, we're going to start this particular conversation from the back end, speaking particularly about the 10 Anglophone leaders who were kidnapped around 5 years ago in Nigeria, and there's a lot of circumstances behind those particular arrests and deportation that have caught the attention of international human rights law, as well as seen as violations against international law. So that is certainly still an ongoing procedure, and Barrister Amungwa is going to be unpacking that one for us. Thank you so much, Barrister Amungwa, for joining us in this conversation. Good morning.
Good morning, and thank you very much for having me on your show. As you said, I am the spokesperson for the defense team of the Naira 10 that is led by Sisiko Ayub Tabe, and other southern Cameroonian detainees within the context of the ongoing war in the northwest and the southwest regions, that is the former British Trust territory, the southern Cameroons. You just talked about these travesties that surrounded the arrest and deportation of the 10 leaders from Nigeria in gross violation of international law. It is true. It's true. All elements of the international law were violated. First of all, these were people. Some of them were already refugees, and some of them had asylum status. And according to international law, they were not supposed to be deported to Cameroon. International convention gives people who are running away from a crisis, or people who are susceptible to be persecuted, to run away from that area. So these 10 people are people that have run away from Cameroon because they thought they should restore the independence of Southern Cameroon, and they had a meeting to talk about the refugee situation, because while in Nigeria, more and more people were fleeing the war into that country. But unfortunately, they went against the law of refoulement, that is international law, does not. They did not. They were not supposed to send them back to Cameroon, but this was done, and this is contrary to international law. Again, these are people who came out outrightly and declared that they had nothing to do with the nationality of Cameroon. They had denounced the nationality of Cameroon, even upon their arrest or their abduction, rather. They denounced the nationality of Cameroon, and the extant laws in Cameroon do stipulate that issues of nationality are supposed to be handled by civil courts, meaning that if they were arrested in Nigeria and they had to talk in terms of their nationality, denunciation of their nationality, would have been the civil courts in Nigeria that were supposed to handle that issue, not for them to be returned to Cameroon and be court-martialed. So all elements of international law were violated. Nigeria does not have any repatriation treaty with Cameroon, but this happened and they sent. So all along, we've been struggling, and you know the way the case was done in Cameroon. There was a charade that took about 19 hours. 19 hours, and it ran from the 18th to the 19th of August 2020. And then the lawyers withdrew their appearances. We withdrew our appearances. I still remember the spokesperson at the time, and up to now, lawyers withdrew their appearances, and the laws in Cameroon say that people that are standing charges, felonious charges like terrorism, secession, and all of that, they must be provided with legal counsel. That is, they were supposed to have legal assistance. The laws in Cameroon say that they were supposed to have, even if we had withdrawn. But they moved ahead to try these people and to slam them live jail without having laws to defend. So this is, it's a package. If you put this together, you understand that nothing has happened since these people were abducted from Nigeria regularly as far as legal operations are concerned. So all along, we've been witnessing a shadow of it, travesty of justice, repression, and nobody raises his head, up to the level where they were even denied their right to speak English, because when we appealed the judgment of the military tribunal in Yaoundé, it went to the appeal, and behold, just because our clients, the 10, wanted to express themselves in English, they were denied that opportunity, and the judgment was again upheld and sustained at the appeal court. And we moved to the Supreme Court. It is more than a year that we filed our grounds of appeal, and up to today, we've never seen anything. We've never seen any reply. All the diligence that we do at the level of the Supreme Court, they are in vain, and nobody wants to talk about the case again.
Get set and be ready to go. On the Move with Barrister and Benjamin Mushatama.
Well, we're still unpacking this great and important talking point from the African perspective. Conflicts in Cameroon, 6 years in, and arrests being made, people, displaced, and deaths as well. We're still unpacking this conversation with Barrister Amungwa Tanyi. I know that we also have Barrister Richard Tambu on the line as well. Thank you so much, Barrister Tambu, for coming on the line with us. We've been trying to get a hold of you to unpack this conversation. Good morning. Oh, well, let's continue with Barrister Amungwa. You spoke about the situation behind the arrests of the 10 individuals and Anglophone leaders who have been arrested since the 5th of January 2018. And, we're sort of ongoing in this particular one. As the spokesperson for the lawyers representing them, I want us to first look at a bit of background, because there might be those listening to this conversation who might not understand the background behind the arrest, as well as the background of the Cameroonian conflict. What exactly is the background of the conflict regarding the Anglophone and Francophone regions of Cameroon, as well as the divisions in law systems?
Okay, the background, succinctly, I will tell you that the background stems from heritage, and it has to do with identity. We are two countries in one, but not really two countries in one per se. The Southern Cameroon has the British heritage with the common law system that is practiced, and then La République du Cameroun practices what we call the civil law system. These two systems had a lot of problems operating as one, despite all the efforts by the system to bring in some cosmetic means in order to actually subsume the common law system. And that is why lawyers way back in 2016 discovered that their courts in the Northwest and the Southwest region were flooded by magistrates who speak just English, who dispense the law in English, whether in French rather. I'm so sorry about that. They dispense the law in French to people who have never crossed the borders to the French territory. And you know the importance of justice as far as the common law system is concerned. Apart from that, the educational system too. But you permit me, first of all, to talk on the legal aspect of it. The common law system gradually was being degraded. It was being subsumed to the extent that they could train somebody in a school in Yaoundé where they call the National School of Administration and Magistracy, and they would just post that person to the Northwest region who is French-speaking to dispense justice in French. The lawyers said no. The justiciable in the Northwest were not, and the Southwest region were not getting their day in court. And apart from that, justice could not be seen to be done in such a mishmash manner. So the issue of language was capital. That somebody cannot speak English and he doesn't even understand French, and you come and you dispense justice to that person. And whose right is that of a person that speaks English? So as a result of that, there was mounting pressure. The lawyers had to go to the streets. And the government came up with some cosmetic measures by calling on the creation of a common law division at the Supreme Court of the Republic of Cameroon. They equally came up with the creation of a common law department in the National School of Administration and Magistracy, Yaoundé, whereas under the common law regime, lawyers are trained in a law school. In Cameroon, we don't have a law school. Lawyers under the common law regime are trained in a law school. But here, we don't even have a law school. Because lawyers are trained in law school, and eventually, as they count their post call into the profession, they are integrated as magistrates. But this is not what obtained in Cameroon. There is a school that they call an ENAM, where you just pack in people, they come out tomorrow, you call them magistrates. So the system is such that it cannot be, you cannot bring the two together. The constitution of the country itself states it unequivocally that Cameroon is a bi-jural system. A bi-jural system because we practice the common law, which is for the people of the former British Trust territory and for La République de Cameroon. But behold, everything has been centralized, and they want to completely eradicate the common law system. The common law system operates on the acquisitorial way of looking at justice, while the civil law, the French law, operates, which is basically supported by the Napoleonic Code, is the inquisitorial system. Let me rapidly explain this. In the inquisitorial system, the prosecution is bound to prove their case beyond reasonable doubt, meaning that a suspect, a defendant, or an accused who is brought before any judicial officer, it is the judicial officer that is supposed to justify the reasons why the person is there. But under the French system, once you are called a thief, you are the person to prove your guilt. You are the person. So these are basically some of the things that make the two systems very difficult to work side by side.
We are on OpenView Audio Bouquet, Channel 628. Channel Africa, the African perspective.
Let's take a look at what's going to be happening going forward. There's still a lot of changes taking place. This conflict has been taking place for plus minus 6 years now, and there's still a lot of new introductions. We do know that last year there were a lot of new decisions taking place as part of the ongoing project on judicial institutions and conflict resolution. There's a lot of, common law division between July 2021 and February 2022, and there's a lot of new decisions that have been taking place. What can we expect when it comes to, the new procedures and processes going forward between the Anglophone and the Francophone in Cameroon?
Well, it is inconsequential. The decisions are inconsequential because before the Southern Cameroon and La République Cameroon came together, the Southern Cameroon operated their judicial system, wherein we still have the High Court rules that we used today in the Northwest and the Southwest region. So the Southern Cameroon is a people that had their judiciary, and all the attempts, the creation or centralization of the common law division at the level of the Supreme Court in Yaoundé is just a way to play for time, so that the French, with their overwhelming repressive method, try to distract public opinion. Even findings that were done at the level of files that were brought over here, the findings, they are doubtful because the quality of people that carried out that research. Research was supposed to be done with people, with lawyers, like practicing lawyers who are, like some of us, who are in the system, and we attend these courts almost every day, especially on cases that touch on the crisis in the Northwest and the Southwest region. So all attempts can't work. The Southern Cameroon should be allowed to run their common law system. The French Cameroon should be allowed to run their common law system, because justice dispensed over in the French territory can never be the same. The procedure itself is so cumbersome. In Southern Cameroon, we don't know about an examining magistrate. But in French Cameroon, there is somebody they call the examining magistrate who can keep a suspect or who can keep a defendant in prison for at least 18 months without trial. And that is why you observe that most of the people that are arrested in the Northwest and the Southwest region that are brought over here, they have the magistrates that they call exam magistrates can keep them in prolonged pre-trial detention for 18 months. This is uncalled for. This is justice that is denied for a people, because one of the characteristics, even in international law, is that as soon as somebody is brought before the court, he should be tried immediately. But this is all the attempts and all the research that have been done, all of what they want to call on left and right, it can't work. Even the laws that are brought in order to the laws on the use of official languages, it cannot work. French remains to be French and English remains to be English. Common law remains to be common law, and French and the civil law remains to be civil law. You cannot fuse these two systems together. It is like putting kerosene on water. The kerosene will always float, and the water will remain beneath. So there is no way that we solve this problem, apart from allowing the former British Trust territory to go with their system, a system that they have their courts before they came into federation with La République Cameroon. Be mindful that La République Cameroon had independence on the 1st of January 1960, while Southern Cameroon had their own in 1961, though with some clauses that had to tie them. So unfortunately, even coming into federation, the legal system of Southern Cameroon was not supposed to be subsumed by La République Cameroon. So all of what you call measures that have been taken, the creation of what division in Enam, the creation of the common law division at the Supreme Court, the creation of, the decree on the use of official languages, the decree on the bilingualism and multiculturalism, all of these are cosmetic measures, and it is just playing for time and distracting the international community not to solve the root causes of the problem. We are two people in one, and the two systems cannot operate commonly. They cannot be fused together. Some other thing can be done because the level of deceit is so devastating. How can you imagine that people that are facing felonious offenses that will fetch them life jail and even death sentence are sentenced without being assisted by lawyers, like the Naira sentence that were tried at the military tribunal? How can you imagine that somebody speaks English? He comes to court and they deny him the right not to speak English, and they want to impose an interpreter that is approximate to him? This is uncalled for. So the two systems cannot work. It can't work. It's like water and kerosene, or water and petrol or gas. It cannot work. So everything that is being done here is just to show to the eye of the community, international community, efforts are being made, but it cannot work. Even if you give the next 100 years for the two systems to work, it cannot work. There are many attempts even to bring.
Well, we are running a little bit over time now, so let's wrap it up really quickly. I'm going to wrap up with you, Barrister Amungwa. What are the processes that can be expected going forward to finally see the release of the 10 Anglophone leaders that are still being detained?
We have the ruling, the Abuja ruling. The Abuja ruling actually came in to solve the problem, because I should call the La République du Cameroon and Nigeria two rogue regimes that don't respect their own laws. You know, there's a ruling that came out in Abuja, and we are at the Supreme Court in Nigeria, and we are working towards that. That ruling actually said the 10 and others that were arrested in Nigeria should be returned to Nigeria, and they should be duly compensated. And some amounts of money were given. The court awarded some damages that the state of Nigeria was supposed to pay. Up to today, Nigeria, like Cameroon, two rogue regions are not going to apply that. The United Nations Working Group came up with a decision giving the state of Cameroon 6 months. They have served Cameroon and Nigeria summonses to file their submissions, which they did not. And today, they are unable to apply the United Nations, and they are members of the United Nations. And they have representatives at Geneva that are supposed to represent both countries when it comes to issues of violations of fundamental human rights. You know, issues of fundamental human rights are very, very fundamental. And we don't treat them with levity like Cameroon and Nigeria are doing. It is just the level of dictatorship and repression that marks these two countries, that think that they're operating in another planet. But we think that as the days go ahead, there must be a solution to what is happening here. And we understand that the international community is gradually getting echoes of what is happening in Cameroon. They are feeling the impact with refugees that are running into their countries. We know that the Senate in America, the European Union, the Reichstag, the British House of Commons, they've come up with method decisions calling for a peaceful resolution, and for it to be done, they must address the root causes of it, because these are two countries with two identities that managed to come together. But unfortunately, we are seeing in history one black African country struggling to colonize another one. Even the president of the Republic of Cameroon, Mr. Paul Biya, went to France, and he told Mo Ibrahim during his conversation that they attempted to assimilate the English system, and it didn't work. So,
Barrister Tambu, unfortunately, I will have to stop you there. We have run out of, Barrister Amungwa, we have run out of time for the conversation. It has gone on for longer than we had anticipated. Barrister Tambu, I'm so sorry for getting you in so late. We've been having a lot of problems trying to get you on the line, and it is unfortunate that we've run out of time for all the things that I wanted to ask you. But I wanted to find out just quickly, in your opinion, do you think that some some of the recommendations that we can look forward to, that we can hope for, is that there are amendments to the Supreme Court of Law of 2006 so that common law procedures can be applied in the common law division of Cameroon, and that we appoint new trained judges in the common law division to make sure that we alleviate the pressures on existing judges. Barrister Tambu, can you please answer that for me swiftly so that we can wrap up?
Yes, please. The short answer is it can work if there is good faith. And the bigger and longer answer is that, in my humble opinion, I think that it will not work because it's only a cosmetic measure. It's like treating an illness without actually going to the causes of the illness. This, like I said, this was a horrible historical mistake that was made. And until that mistake is corrected, all other measures that are being taken will only be cosmetic. Because if you alleviate, if you bring in more judges and you open up a common law section without actually implementing the spirit of the common law, this will not work. And until the root cause of this situation is actually addressed and resolved, we cannot get anywhere. So the short question is, the short answer is, it can work with good faith, and that good faith depends on addressing the root causes. But the very, very short answer is no, it cannot work for the moment. Thank you.
Well, thank you so much for that particular reply and your participation. Barrister Amungwa as well as Barrister Tambu, I really appreciate your time today. And, all the best in making sure that, you continue fighting for the rights of the Anglophone people there in Cameroon. And, we do hope to see a peaceful Cameroon in the future. Whether that will be the near future or not, we are still hopeful.
Yes, a just Cameroon, a just. A peace without justice means really nothing, my dear anchor, because the whole idea of peace has predicated all of Africa all this while. And all of Africa, we have tried to be peaceful for the last 50 years, and it has not worked. We need a just, equitable, and judicial system that works for everybody. That is what we need. And that is why the war is still raging, because we need justice and peace, not just peace as a standalone thing. Thank you so very much.
That podcast was courtesy of Channel Africa, the African Perspective.